All right, welcome to the deep dive. You ready to dive in today?
Always.
Okay, good. Today we're tackling privity of contract in UK law.
Ooh, a good one.
Yeah, and we've been looking into we've got a whole bunch of podcasts all about privity of contract.
Sounds fascinating.
Yeah, and it's something that you wouldn't think would be so important in your everyday life, but it really is.
I think a lot of people would be surprised.
Absolutely.
Yeah.
So let me give you an example. Imagine you're planning a wedding, and to help with the costs, your dads decide, hey, we're going to, split the expenses.
Okay.
Everything's great until they back out of the deal.
Oh, dear.
Yeah. So now what can you do? Can you actually sue your dads?
Well, that's where this idea of privity of contract comes in.
Yeah, so tricky.
It can be really tricky.
So let's break it down.
Okay.
What is this privity of contract thing anyway?
Well, at its core, privity of contract is all about who has the right to enforce a contract.
So it's like a VIP list for the contract.
Yeah.
Only those specifically named get all the benefits and, of course, all the responsibility.
That's a great way to put it. And it means that even if a contract was made to benefit someone, if they weren't part of that original agreement, they can't enforce it.
Makes sense in a way, right? You don't want random people coming in and saying, hey, that contract's for me too.
Exactly. It's about keeping contracts predictable.
Keeps things clean.
Exactly.
Okay, but now let's talk about what this means in real life situations, because that's when it gets interesting.
Absolutely.
There's this one case, Beswick v. Beswick. Have you heard of this
Oh,
one?
yes, a classic.
It involves this coal merchant who's getting ready to retire, and he makes a deal with his nephew.
Okay.
The nephew's going to take over the business, but in return, he promises to pay the merchant's widow a weekly annuity.
So after the merchant dies.
Exactly.
Okay.
So clearly the intention is to benefit the widow, right?
Absolutely.
But then, as often happens in these cases, the nephew breaks his promise. So now what can the widow do? Can she enforce that agreement?
Well, that's where things get tricky. Initially, she couldn't.
Why not? Seems pretty straightforward.
Because under the strict rules of privity of contract, she wasn't actually a party to the agreement.
She wasn't on the VIP list.
Exactly. The contract was between her husband, the coal merchant, and the nephew.
So even though she was the one set to benefit, she had no legal standing.
That's the initial problem with privity.
Wow. Okay, so what happened to Mrs. Beswick?
The court did eventually find in her favor, but it wasn't a simple process.
Ah, so there are ways around it sometimes.
There are, but this case really highlights how privity can create these difficult situations where there's this clear moral obligation.
She should get this money.
Absolutely. But the law doesn't have a straightforward way to always enforce that. And it raises all these questions about, what's fair?
Who should benefit?
Exactly. And who has the power?
Okay, so we've got this tension between, the strict rules of privity and what seems like the fair or just thing to do.
And that tension plays out in a lot of the key cases on privity.
Okay, so let's talk about some of those cases, because I know there are a couple of landmark decisions that really cemented privity in UK law.
Absolutely. Tweddle v. Atkinson and Dunlop v. Selfridge are both essential for understanding this area of the law.
Yeah, those names ring a bell. Okay, let's start with Tweddle v. Atkinson, because this one's a little closer to home.
Okay.
We're back to the wedding scenario.
Okay.
So two fathers agree to pay the groom, their son-in-law, a sum of money as part of the marriage agreement.
Nice little wedding gift.
Sounds like a good deal, right?
Yeah.
Well, they don't pay up.
Oh, no.
And so can the groom sue?
He couldn't.
What? Why not? He's the one they promised the money to.
I know. It seems counterintuitive, right?
Yeah.
But the court said no.
Because?
Remember that VIP list we talked about?
Uh-huh.
The groom, while he was definitely intended to benefit, wasn't a party to the contract itself.
So he was left high and dry.
He was. And this case highlights a really crucial point. The person who's trying to sue needs to have given something in return for that promise.
Okay, so they need to have skin in the game.
Exactly. It's called consideration. And of course, they need to be a party to the contract.
So privity and consideration, they both have to be there.
Absolutely.
That's a really important point. I think a lot of people don't realize that.
It's a common misconception.
Okay, so let's move on to Dunlop v. Selfridge. This one takes us into the world of business, tires, and pricing.
Bit of a change of scenery.
Yeah, very different. So Dunlop, a tire manufacturer, wants to control the price of their tires.
Makes sense.
Yeah, they want to make sure everyone's selling them at a certain price, no undercutting.
Maintain that brand value.
Exactly. So they have this agreement with a distributor, Dew.
Okay.
Dew's going to sell the tires at a certain price, a set price.
Okay.
Dew then sells the tires to Selfridge, who also agrees to stick to that price restriction.
So far, so good.
But then Selfridge decides, I don't care about the rules, and starts undercutting the price, selling the tires for cheaper.
Oh, that's not good.
No. And this is where the case gets interesting. So Dunlop tries to sue Selfridge directly.
Makes sense, right?
Yeah, they're thinking Selfridge broke the agreement, we're going to get them.
Hold them accountable.
Right.
But the court said no. No.
Why?
Privity. There it is again.
They said Dunlop couldn't sue Selfridge directly because there was no contract between them.
Oh, so their contract was only with the distributor, Dew.
Right, so even though Selfridge broke that agreement about pricing, they weren't directly liable to Dunlop.
Okay, so this is all starting to make sense now. Privity is like this legal shield protecting people from being held accountable for contracts they didn't make themselves.
It's one way to think about it.
Okay, so up to this point, Privity sounds pretty straightforward, almost like a no trespassing sign for contracts.
Good analogy, but there's got to be some wiggle room, right? There must be times when someone who isn't a party to the contract can still have some rights.
You're right. The law is rarely that black and white.
Okay, good. Because I was starting to get a little nervous.
It's like a detective novel. We have to look for those clues, those loopholes, the unexpected twists.
Ooh, legal mysteries. I love it.
So let's start with the idea of a guarantor.
Okay, guarantor.
Imagine someone needs a loan, but they need someone to vouch for them. Someone to say, hey, if they don't pay, I will.
Okay, so they're taking on the risk.
Exactly. And if the borrower, doesn't pay up, the lender can go after the guarantor for the money.
So they made a promise they have to keep it.
Right, but here's the twist. After the guarantor pays up, they can then turn around and sue the original borrower to recover their losses.
Ah, okay. So even though they weren't part of that original loan agreement, they gained the right to sue because they fulfilled an obligation.
Precisely.
So it's like they step into the shoes of the original party to the contract.
That's a great way to put it. It's called subrogation.
Subrogation. Okay, I'm adding that to my legal vocabulary.
It's a handy one.
Yeah.
And it's just one way a third party can gain rights related to a contract, even if they weren't initially involved.
Clever. Okay, so we've got guarantors. Any other exceptions to privity out there?
Oh, plenty. Another key one is the concept of trusts.
Trusts. Okay.
So imagine a trust fund set up for a child.
Classic trust fund kids scenario.
The parents create the trust, a trustee manages the money, but the child, the beneficiary, has the right to benefit from that trust.
Right, so even though they weren't there at the beginning, signing papers and whatnot,
Exactly.
they still have enforceable rights.
They do. They can take action if the terms of the trust are violated, even though they weren't a party to that initial agreement.
So we're starting to see those cracks in that privity wall.
We are.
Okay, now you mentioned tort law earlier. Does that come into play with privity at all? Like, what about cases where someone gets hurt because of negligence?
Well, that brings us to the very famous case of Donoghue v. Stevenson.
Donoghue v. Stevenson. This is the one with the snail.
The one and only. A woman in Scotland buys a bottle of ginger beer and finds, to her horror, a decomposed snail inside.
Ugh, I can't even imagine.
It's a nightmare scenario.
Absolutely. So she gets sick and wants to sue the manufacturer.
Right, but here's the question. Can she sue even though she didn't buy the ginger beer directly from the manufacturer?
So this is where privity comes in.
It does.
Does it stop her from suing?
It doesn't. This case was a landmark decision. The court said the manufacturer had a duty of care to make sure their product was safe, regardless of who bought it from a shop.
So even though there was no direct contract between her and the manufacturer,
Right.
there was this broader duty of care.
Exactly. And this case shows that tort law, which is all about protecting people from harm, can sometimes override those strict rules of privity of contract.
So privity isn't always a get-out-of-jail-free card.
Especially when it comes to consumer safety.
Right. Companies can't just hide behind privity if they're putting out dangerous products.
Absolutely. And there are still more exceptions to explore.
More twists and turns.
Oh, yes. We'll delve into agency, collateral contracts, and even some creative legal maneuvers in part 2 of our deep dive.
Ooh, the plot thickens. All right, listeners, stay tuned because we're just getting started. All right, welcome back to the deep dive. We are picking up right where we left off, still exploring this fascinating world of privity of contract.
Yeah, last time we saw how those strict rules of privity can sometimes clash with what seems like the fair thing to do.
Exactly. And we started to uncover some of the exceptions, like with guarantors and trusts and, of course, tort law coming into play.
It's like we're peeling back the layers of this legal onion.
I like that analogy. Okay, so where are we headed next in this legal labyrinth?
Well, let's dive into the world of agency.
Okay,
It's
agency.
a pretty important concept in contract law.
So break it down for me. What is agency all about?
Think of it like this. You can authorize someone to act on your behalf, legally speaking.
Okay, so they become my legal stand-in.
That's a good way to put it. They can enter into contracts, make decisions, all sorts of things, but all in your name.
I'm picturing a scene from a movie, someone signing a contract with a flourish on behalf of.
Exactly. Now, here's where it gets interesting in terms of privity of contract. If an agent makes a contract on your behalf, you are bound by that contract.
Even though I wasn't there at the negotiating table.
Even then, your agent's actions become your actions in the eyes of the law.
Okay, I can see how that could get complicated. So do you have any good real-world examples of how this agency thing works?
Oh, absolutely. One that comes to mind is Scruttons v. Midland Silicones.
That name rings a bell.
Yeah, it's a classic case that shows how tricky agency can be. It involves shipping, a damaged barrel of chemicals, a whole lot of legal wrangling.
Sounds messy.
It was. So, Midland Silicones had this contract with a carrier to ship drums of chemicals.
Okay.
Now, their contract had a limitation clause.
The limitation clause, what's that?
It basically limited how much the carrier would be liable for if any damage happened. It capped their responsibility at a certain amount.
Okay, so it's like a safety net for the carrier.
Exactly. Now, the carrier hires these stevedores, Scruttons, to unload the ship.
Stevedores, that's the guys who do the heavy lifting, right?
Yeah, the ones who actually unload the cargo.
Okay.
So during unloading, guess what happens?
They drop a barrel.
Bingo! And it causes significant damage.
Expensive mistake.
You bet. So Midland Silicones, they want to go after Scruttons for the damages.
Makes sense. They're the ones who messed up.
Right, but remember, there's no contract between Midland Silicones and Scruttons.
Ah, their contracts was with the carrier.
Exactly. So they can't sue Scruttons for breach of contract.
Okay, so they're stuck.
Not quite. They get creative and decide to go for a tort claim, arguing negligence.
So they're trying to bypass the privity issue by claiming a different type of legal wrong.
Exactly. They're saying, hey, even if there's no contract, you were still negligent and caused us harm. Now, during all this back and forth, Scruttons find out about that limitation clause in the original contract between Midland Silicones and the carrier.
Ah, the one that limits the carrier's liability.
Yep. And they try to argue that they should be protected by that clause too.
Even though they weren't a party to it.
Even though their reasoning was that the carrier had acted as their agent when entering into the contract.
So they're trying to use agency as a shield to limit their liability.
That's the idea. They're saying, hey, the carrier was representing us when they made that deal, so we should get the benefit of that limitation clause too.
Did it work?
Nope. The court said no.
Why not?
Because they found there wasn't enough evidence to show that the carrier was really acting as Scruttons' agent when they negotiated that contract.
So it's not enough just to say, oh, they were our agent. There has to be more to it.
Exactly. That limitation clause didn't even mention the stevedores specifically.
So it's like they were trying to crash a party they weren't invited to.
Perfect analogy. This case shows how just because someone's doing a task for you, it doesn't automatically make them your agent in the eyes of the law.
So what does make a valid agency agreement? Are there rules about this?
There are, and they're important. The judge in this case, Lord Reed, set out 4 key conditions for a valid agency relationship.
4 conditions, okay. I know what to say.
First, there needs to be a clear intention to protect that third party, the stevedores in this case.
Okay, intention.
Second, the contracting party, the carrier in this case, has to have been acting as an agent for that third party.
So they have to be acting on their behalf, explicitly.
Third, that third party, the stevedores, need to have authorized the agent to act for them.
So they have to have given their permission.
Exactly. And finally, there has to be consideration.
Consideration, we talked about that earlier.
It's a key concept in contract law. It means that something of value has to flow from the principal, Midland Silicones in this case, to the other party.
So all these pieces have to be in place for the agency defense to work.
All of them.
Okay, so in Scruttons, some of those pieces were missing, like the explicit intention and the consideration from Midland Silicones to Scruttons.
Exactly. And that's why their agency argument failed.
Got it. So agency can be a bit of a minefield, but I'm guessing there are cases where it does work as an exception to privity.
Absolutely. There's a contrasting case, the Eurymedon, that shows agency in action.
The Eurymedon. Okay, let's hear about this one.
This one also involves shipping. We've got a shipper, a carrier, and you guessed it, stevedores again.
Shipping seems to be a popular theme in these privity cases.
It's a globalized world. So the shipper has a contract with a carrier to transport goods.
Okay, standard stuff.
The carrier then subcontracts the unloading to stevedores. Now here's a key detail. The stevedores were actually a subsidiary of the carrier company.
So they're connected, but still separate entities.
Exactly. Now that shipper's contract with the carrier had a really broad exemption clause.
Like a superpowered limitation clause.
You could say that. It basically said the carrier and anyone working for them, like servants, agents, or employees, were shielded from liability for damages.
Okay, so they really cover their bases.
They did. So, as you might expect, the stevedores end up damaging the goods during unloading.
Stevedores and damaged goods, it's a recurring theme.
It seems to be. So, what do the stevedores do?
I'm guessing they try to use that exemption clause to protect themselves?
You know it. They're saying, hey, we're covered under this clause as agents of the carrier.
It did work this time.
It did.
Right.
The court agreed that the carrier had acted as an agent for the stevedores, giving them the benefit of that exemption clause.
So what was the difference between this case and Scruttons?
A few key things. In this case, the shipper knew about the stevedores being involved. The contract even mentioned others.
Okay, so there was that intention to protect them.
Right. And the stevedores had given the carrier permission to act as their agent when they negotiated the contract.
So, unlike Scruttons, all those conditions for a valid agency agreement that Lord Reed set out, they were all met.
Spot on. There was the intention, the authorization, and the consideration was there too.
Okay, but wait a minute. The stevedores didn't give the shipper anything in return for that protection, did they?
That's a good point. But the court decided that in these situations, if you're already obligated to do something for a third party, that can count as valid consideration.
So in this case, the stevedores were already obligated to unload the goods for the carrier, and that counted as their contribution.
Exactly. It's like their existing duty became their consideration for being included under that exemption clause.
Wow. It's amazing how these subtle details can completely change the outcome of a case.
That's the thing with law. The details matter. This is why understanding agency is so important in the context of privity.
You might think you're protected, but if that agency relationship isn't crystal clear, you could be in for a nasty surprise.
Absolutely. But our journey through the exceptions to privity isn't over yet.
More to come.
Oh, yes. We still need to talk about collateral contracts.
Collateral contracts, what are those?
Think of them as side deals or promises that can create unexpected legal relationships.
Sounds intriguing.
It is. We'll unpack all of that in part 3 of our deep dive.
Okay, listeners, stay tuned for the final chapter in our Privity of Contracts saga. All right, welcome back to the deep dive. We've journeyed through the winding roads of Privity of Contract, uncovering all sorts of legal twists and turns.
It's been quite a ride. From guarantors and trusts to tort law and agency, we've seen how privity can create these fascinating legal puzzles.
Exactly, and just when you think you've got it all figured out, there's always another layer to uncover.
That's the beauty of law. It's always evolving.
Absolutely. So before we wrap up this deep dive, there's one more exception to privity that we need to tackle.
Okay, what's on the agenda?
Collateral contracts.
Ah, yes. Those can be tricky little things.
They sound a bit mysterious.
Yeah.
So what are we talking about here? What exactly is a collateral contract?
Well, think of it like this. Sometimes there's a main contract, the big agreement everyone's focused on.
Okay.
But then there might be these side agreements, these promises or assurances made that aren't part of that main contract.
Okay, like a wink and a nod kind of deal.
Kind of. But these side deals, these collateral contracts, they can actually have legal weight.
Really? So even if they're not written down in the main contract, they can still be enforced.
Exactly. That's why they're so important to understand, especially in the context of privity.
Okay, I'm intrigued. Do you have a good example? A case where this collateral contract thing came into play?
There's a classic case, Shanklin Pier v. Detel products, that really illustrates this concept.
Shanklin Pier. Okay, paint me a picture. What happened?
Shanklin Pier, as you might guess, owned a pier.
Okay.
And they were looking to get it repainted.
Makes sense. A fresh coat of paint can do wonders.
Absolutely. Now, they were talking to these paint contractors about the job. And during those conversations, Detel Products, a paint manufacturer, comes along and says, hey, use our paint. It's the best. It'll last for years.
So they're making a big sales pitch.
Big time. They give all these assurances about the quality and durability of their paint.
They don't have a contract with the contractors
Yeah.
about the paint quality, right? That was just about applying the paint.
Right, and they didn't buy the paint directly from Detel.
So it's a privity problem again.
Exactly. But the court got creative. They said, hold on a minute. Those promises that Detel made directly to Shanklin Pier, those created a collateral contract.
So even though there wasn't a main contract between them, those side promises formed a separate, legally binding agreement.
That's what the court found. And because of that collateral contract, Shanklin Pier could sue Detel directly for breach of contract.
Wow. So even those wink and a nod deals, if they involve clear promises and reliance, they can have real legal teeth.
Absolutely. This case shows that courts are willing to look beyond the main contract to see if there are any side agreements that might impact privity.
That's a powerful reminder to be careful about the promises you make, even if they're not part of a formal written contract.
Couldn't agree more. Now, before we wrap things up completely, there's one more exception to privity we should touch on. Assignment.
Okay, assignment. We've heard that term before.
It's a pretty straightforward concept. It's basically transferring your rights and obligations under a contract to someone else.
So like handing off the contract to a new player.
Exactly. Imagine you're moving and want to transfer your gym membership to a friend. If your contract allows for assignment, you can legally hand over your rights and responsibilities to your friend.
So my friend steps into my shoes, legally speaking, and becomes the new party to the contract with the gym.
Precisely. But remember, not all contracts allow for assignment. The original agreement might say no to assignment, or it might have conditions.
So it's not a free-for-all, there are rules.
Always rules. Always check that fine print, and if you're not sure, talk to a legal expert.
Solid advice.
Yeah.
Okay, so we've covered a lot of ground here. Guarantors, trusts, tort law, agency, collateral contracts, assignment, even those situations where courts have basically bent the rules of privity to make things fairer.
It's been quite the legal adventure. Privity is a cornerstone of contract law, but as we've seen, it's not always a simple yes or no answer.
There are all these exceptions and nuances, and it seems like courts are willing to get creative to make sure justice is served.
That's a good way to put it, and that's why understanding privity is so important.
Absolutely. So for our listeners out there, what's the key takeaway from all of this? What do they need to remember?
I think the big takeaway is this. When you're entering into a contract, don't just focus on the big picture, the main agreement. Think about those side deals, those promises made on the sidelines, and be aware of who might be affected, even if they're not directly signing on the dotted line.
Because, as we've seen, those side deals and those invisible players can sometimes have a big impact on who has rights and who can be held accountable.
Exactly. And remember, if you're ever unsure, don't hesitate to seek legal advice.
Always sound advice. Well, I think we successfully navigated the labyrinth of privity of contract, thanks to our expert for being our guide.
My pleasure. Always happy to delve into the intricacies of law.
And to our listeners, we hope this deep dive has given you a newfound appreciation for the complexities and the importance of privity. Until next time, stay curious and stay informed.